SJC-13479, Commonwealth versus Jerion Moore. SJC-13478, Commonwealth versus Nicholas Cessalon.
Okay, Attorney Schnipper.
Good morning, Chief Justice Budd. May it please the court. I'm Merritt Schnipper here today on behalf of Jerion Moore. My time before the court today is brief, so I'd like to take the court directly to the question of Chapter 234, Section 68C, and how that statute balances a defendant's rights to be protected against double jeopardy against the public interest in fair verdicts in criminal cases, which is the only significant other interest in play here. As Arizona versus Washington shows, and this court has echoed many times, the double jeopardy protection includes a defendant's valued right to have his or her fate decided by the particular jury before which jeopardy is already attached. In other words, a defendant has a constitutional right, separate from the questions of multiple prosecutions or duplicative convictions, to be tried one time and one time only. Of course, in this case, there's already been two full trials, two full opportunities for the government to carry its burden. It's been unable to do so, and we've had two hung jury mistrials. Balanced against the defendant's double jeopardy right, the only other interest in play is the public's interest in a fair verdict. And in this context, a fair verdict simply means a verdict that's rendered by an impartial jury, or a verdict that is not coerced out of a jury. And manifest necessity basically is a way of saying that in a very particular circumstance, a defendant's double jeopardy rights must yield to the public interest in a fair verdict. I think these are all accepted propositions. The question becomes, what steps does the judge have to take to ensure that manifest necessity actually exists? Section 68C specifically says that after a second return without a verdict, which there's no dispute we have here, the jury may not be sent out again without their own consent. So in other words, further compelled deliberations at that point are prohibited, but consented to deliberations are permitted. And in fact, as this court's decision in Jenkins shows, can actually produce the break of a logjam and result in a verdict from a jury that formally had stated it was unable to reach one. So the question is, under what circumstances must a judge ask, or another way of saying, how should a judge guide their discretion in determining whether to ask whether a jury will consent to continued deliberations? Here we had an express request from the defense in light of everything that had gone on, and we're not just talking about one trial, two trials, and at that point more than 4 years in the pretrial phase. We would like you to ask the jury, notwithstanding their stated deadlock, whether they will consent to further deliberations.
But why would the fact that the defendant asked for that make a difference in terms of assessing the judge's decision-making? Because presumably the decision-making is based on her assessment of the jury's impasse, right? Whether, if the judge is convinced that asking for consent would veer towards coercion, or the risk of coercion, then the fact that the defendant asked for the judge to see if they would consent, that doesn't seem to me to go anywhere.
Well, I have 2 points to make there. The first is that I respectfully disagree, because we're talking about the defendant whose double jeopardy rights are at stake here, right? This is the person whose constitutional right is in play.
Sure, but once they then, if the judge were to ask the question you had proposed and they returned a guilty verdict, then wouldn't the defendant be arguing the verdict was coerced?
How could the defendant make that argument, A, in light of his own request, and B, in light of Jenkins?
So
I don't see.
it would just be estoppel? He would lose his rights because of estoppel. He could.
Well, if he were to request continued deliberations and then those deliberations were to have continued, it's hard to argue how that invited error would then be subject to appeal. But let me just get to the question of how we can second guess, or how a judge can decide whether or not she's going to be coercing a verdict, right? Jenkins answers that question. You begin your request by saying, my ability to coerce you or to compel you to continue deliberations is at an end. You are free to go home if you now choose. I would like to inform you that notwithstanding your stated inability to reach a verdict, the parties in this case would request that you consent to some amount of continued deliberations. That's up to you to decide. So obviously it's a baseline principle of appellate review that juries are presumed to follow judicial instructions. If a judge informs the jury that they no longer have to continue deliberating and that the court lacks any power to compel them, you have removed the possibility of a compelled and coerced verdict. Right? So at that point, you've eliminated, or you shouldn't have been eliminated, you've protected the only interest that counterbalances the defendant's double jeopardy rights. So at that point, I would argue a judge shouldn't have any discretion not to ask. And the reason the judge shouldn't have any discretion not to ask is by prefacing his or her request with the statement that the ability of the court to compel further deliberations is at an end. The public interest is protected, and the public interest in a fair verdict is the only interest that can possibly outweigh a defendant's double jeopardy rights. I see I'm over my time. I'd just like to say the dangers and the harms that are posited by cases by Arizona, like Arizona v. Washington, which this court discussed in Commonwealth versus Cruz, are realized here. These young men have spent 6 years in the House of Correction, now awaiting a third trial. The Commonwealth has been unable to carry its burden twice at trial. So they're heading into a third trial, and to simply say that a judge exercises discretion kind of on a gut based on the jury, to simply not, I would say, take the final step before determining that there actually exists a manifest necessity, that's a violation of double jeopardy rights. And I think that should prohibit a further retrial.
Okay.
If there are any further questions, I'll rest on my brief. Thank you.
Okay, Attorney Kelly.
Good morning, may it please the court. Brian Kelly on behalf of Nicholas Cisalon. Rather than saying what he said for the next 3.5 minutes, I'll just focus on the sufficiency argument. This is a case, as the court well knows, was tried twice, once in 2021, again in 2022. In the second case, there were 6 days of evidence with 3 days of jury deliberations. So the question that I posit is, if the government can't prove this case, what more evidence is there, or anecdotal evidence you might say, that they cannot sustain their burden in this particular case? And the standard we all know is in the light most favorable to the government, but any rational juror can find the elements of the offenses beyond a reasonable doubt. So I just dovetail back into that question. We've had 2 trials, 2 hung juries. I submit to the court that that's very good evidence that the government cannot demonstrate beyond a reasonable doubt any of these elements, or even one of the elements. But, so what I would say, just to sort of go straight into the facts of this particular case, you could concede that on all of the evidence in the light most favorable to the government, that the defendants are near the scene of the crime. So you have about, I think, 4 or 5 witnesses that describe 2 people running through this courtyard. The court has seen any of the exhibits in this particular case. You know, it's almost like a fishbowl. It's like right across the street from the homicide, where this used to be, is across the street from the homicide, Boston Police. And there are exits everywhere. So you got 2 people running, and you hear multiple witnesses saying different things. But even if you narrow that down and distill it to, in the light most favorable to them, you have an individual by the name of Mr. Harris who's looking out his window. He sees an individual with a full red hoodie. And the reason why I think that's important is because none of the other witnesses say that. And the Commonwealth will talk about a hoodie sticking out of Mr. Moore's jacket. And that's fair. He's in the area potentially. They can probably demonstrate he's in the area. But what evidence do they have that demonstrates that these 2 guys are the shooters? They have no motive. And I understand they don't have to prove motive, but it is usually used as anecdotal evidence or evidence to demonstrate some connection here. The case that most everybody has cited here is this case Davis, which Davis comes up once on this GPS issue, then goes back, and then it comes back up on a question of the insufficiency of the sufficiency of the evidence. This court says sufficient. But when you look at the first decision, you can see some real differences in that evidence and this evidence. One of the biggest pieces of evidence, and for some reason we're dealing again with a red piece of clothing, but there's a red piece of clothing that's found in that individual Davis's home 7 days after the incident. They also have GPS points, data points, that demonstrate a flight path that is not consistent and not true in this particular case. So to me, the question is and I would also point out in this particular case, I'm sure the government will talk about this, what they claim is consciousness of guilt evidence. That is, the 2 defendants allegedly get into an Uber and they're directing him. And I suggest to the court that that's not determinative of this question of, you got 2 young men, African Americans, they're leaving the scene of a shooting. it's easily explainable that they get into an Uber because they're concerned that there's a shooting behind them. So the main question I would focus the
But didn't the driver testify that, or there was evidence that they also asked the driver to take a different route from what the driver was being fed by his directions, and that
all the time.
the driver said that had never happened in the driver's years of driving.
In the 7 years that he had been, that's true, right?
And can you also talk about the gunpowder residue on the coat?
So there's, on Mr. Moore's jacket, and I believe it's 16 days after the offense, they find gunshot residue on the, I believe, the sleeve of Mr. Moore. And I agree that that's obviously something that the government's going to focus in on, but I suggested to the court the amount of time that's gone by. I mean, we're talking about 2 weeks, a little more than 2 weeks. I don't know that again, is determinative in terms of the shooters of this particular case. I see what Your Honor is talking about. If you look at this Davis case that I've talked about, Davis, there's a very similar piece of clothing. But I would just direct the court back to what the Commonwealth would have to show in order to show that's the jacket, though, right? Because Harris says it's a red jacket, not a black jacket. So how far are the inferences allowed to be piled on? Moore would have had to have the jacket somewhere nearby, right? So I guess the argument would be they commit the shooting on a guy they don't know, there's no connection to, there's no motive, there's no evidence as to why they would even know this guy was there. He puts a jacket somewhere, which there's no evidence of. There's no witnesses who say that. There's no evidence of that. They disappear on the video. I'll acknowledge that. They're gone. But when would he have put this jacket on? I mean, you look at the timeline, which I've gone through in the brief. It's like an Olympic speed to get to the front of this building. So I get where the court's going, but I would just point out that the jacket is totally different than what Mr. Harris has described as the shooter's jacket. He's wearing a full-length jacket. He doesn't say anything about a jacket being over that. So what I would focus the court in on is really what I always struggle with in these cases is how many inferences can they make? How many inferences can they draw? How many inferences can be piled on top of one on the other? Because in this particular case, what you see is what I always think about is the idea that if the inferences are undercut by other pieces of evidence in the case, and Mr. Shipner cited a case which I think is great in this particular issue, Sephoris, I think is the name of the case, where if there's other evidence that suggests it's Sepheus, which says basically that when there are other pieces of evidence that undercut those inferences, the court can take into consideration in deciding whether or not these inferences that the government uses are reliable, usable. In this context, the question of is there a rational juror that could find the elements beyond a reasonable doubt? And the reason I point that out is because, I'm way over, is because when you look at all of these witnesses and what they say, when you look at all of the evidence, at best, I would suggest to the court that all you can say is that Mr. Moore and Mr. Sisselant are at best in the location, which we know is not enough. So I'll rest on that in the brief. Thank you very much.
Okay, thank you. Attorney Lynn.
Good morning, Your Honors. May it please the court. Paul Lynn for the Commonwealth. With me is Assistant District Attorney David Bradley, who is the trial prosecutor in this case. Starting with the treatment of the jury deadlock in this case, and the jury is undeniably deadlocked. They use the word deadlock in their note to the court. They say that we will, I'm not quoting, I'm paraphrasing here, we could not reach a verdict based on further deliberations. In that situation, under Fuentes, which I cite in my brief, the judge can accept that as a statement that the jury is, in fact, will serve no further purpose by being asked to deliberate further. And in fact, as in the case which I had memorized about 5 minutes ago, the federal case on this said that there's such a danger of coercion here, such a danger of the judge saying, well, yeah, I don't really believe you're deadlocked, won't you try some more? And the court said, no, that's not what we want. That's also what this court said in Fuentes. And so for those reasons, the judge acted well within her discretion in ruling that this was indeed a genuine deadlock. Turning to the sufficiency of the issue, we have 3 witnesses here. We have a witness who sees the shooting, sees 2 people. This is not a case in which the defendant is just charged as an accessory, as a getaway driver. This is a case in which 2 men are seen walking to the murder scene for 5 minutes before the murder. They disappear for 2 minutes. Within that 2-minute period, Mr. Harris sees the murder, which is committed by 2 men, one of whom is wearing a red jacket. The videotape of these 2 men clearly shows that the defendant, Mr. Moore, is wearing a red hooded sweatshirt underneath his coat. Then 2 minutes, within 1 minute after the shooting, these same 2 men are seen running out of the housing complex that unfortunately now has been demolished, so it's no longer visible on Google Maps or anything like that, and are seen again walking back the same way they came. This time, Mr. Moore's red hood is tucked under his jacket, so you can just barely see it in one of the videos, and you can't see it from behind. They get in this Uber. They tell the driver where to go, which the driver says is unusual. That's not how an Uber drive generally works. And then 2 weeks later, Mr. Moore is seen wearing a jacket that has gunshot residue on it. Considering all those facts, the evidence, even though it has failed to persuade 2 juries so far, is more than sufficient to prove both defendants' guilt of murder in the first degree in this case. If there are no questions, I will otherwise rest on my brief.
Okay, thank you.